ask, Your Honor. There's two, it's co-appellees.
Oh, okay. I always
So I don't know
get confused there. Yeah. How do you two want to split the time?
I don't need much time for the cross appellants.
You just give me a number. So
If I just take 3 minutes.
okay.
All right.
That'll leave 7 for Mr. Vanderveer. Is that okay?
That's fine.
All right. Just 1 sec. Got her? Okay. Again, this is in re interest of Amanda C. Go.
May it please the court, my name is Matt Kaler. I'm here on behalf of the cross appellant Paul Castigate, who's the father of the minor child in this case. Just briefly, I think one of the most important issues in this case as it pertains to the father is this child and the other 2 children initially were in care for approximately a year before there was ever a judicial finding on the record that no reasonable efforts were necessary. And in that time, there was little to no effort to make any contact with my client or to set up any services despite the fact they were available. The only visit that occurred was one that was, frankly, contrary to a court order. That is one that the caseworker arranged after a death in the family. After that, there was no follow-up with the child's therapist. In fact, the therapist wasn't even aware until the time of the trial that that visit had even taken place. And I had asked for that in cross-examination because, again, I felt it was relevant with respect to best interests, the fact that there had been contact in this matter. Even though that visit, the testimony was that that visit went well, there was no follow-up on that either to determine whether or not it would be appropriate to set up therapeutic visitation. There was never any proof during the trial of any nexus with respect to the allegations that led to the children being placed into care and risk for harm to the particular child that's at issue in this appeal. I think that the court should take that into consideration, the fact that there was a year before the court found that no reasonable efforts were necessary. This was not an immediate termination filing. He was not given a chance, though, despite the availability of services, to participate in any sort of plan of reunification, and despite his availability and the availability of those services. I believe the evidence at the trial fell short of proving aggravated circumstances. There was really no testimony. There was an offer of the conviction from district court, but no further testimony or nexus testimony with respect to the child at issue here. I've already testified with respect to the reasonable efforts. And again, under fundamental fairness, I understand my client was incarcerated through the entire time period this case was in existence. At the same time, though, he was never afforded any opportunity to work with the department. And as far as the best interest testimony, again, I feel it fell short. The therapist had never seen my client with the child, was not aware of the visit that took place, and the caseworker, the entire contact between my client and the department consisted of one face-to-face visit and one phone call, and that's it for the entire time the child was in care. So other than that, I'd submit on the brief, see if anyone has any questions.
Thank you, Mr. Kaler.
Thank you.
Mr. Vanderveer, please. Good afternoon.
Good afternoon, Your Honors. My name is Austin Vanderveer. I'm a senior certified law clerk representing the state today. First, I understand that, as Your Honors had mentioned, fully briefed on the facts, but I think some of them that might need to be reiterated is that, as you heard opposing counsel mention, that there might have been a possible, no link or nexus between Ms. Castigate's mental condition and the termination of parental rights, is that on 2 separate occasions within the time span of 1 year, Ms. Castigate was evaluated, a psychological evaluation was performed on her, and that although there had been an increase in score, the psychologist had still placed her in the, I believe, moderately mentally or suffering from a moderate level of mental retardation, and what should be, I think, expounded on is that there is a 5-point overlap between moderate and mild, but that the psychologist in this case also administered what I believe is an adaptive functioning exam, and as such, those scores were also in the low range, which ultimately led her to place Ms. Castigate in the moderate mental retardation range. Additionally, the psychologist also noted and testified in court that it would be very difficult for someone like this to function or at least be able to parent, let alone maintain a lifestyle for themselves. As such, she, as well as, I believe, Ms. Ertzner, who testified, I believe Dr. Linder was the psychologist, to clarify that, and Ms. Blevins and Dr. Erzner all testified that it would be in the minor child's best interest to terminate the parental rights of Ms. Castagay. Additionally, Your Honors, I think it's relevant to point out that it was overheard that Pauline actually said to Paul Jr., Pauline being Mrs. Castagay, at the wake of Amanda, who is now deceased, that, and I quote, if he didn't start